Hello, I'm Jessica Mills, and I'm here today with John Spender, Chair of the LIV's Family Law Section Maintenance and Property Committee, a long-standing member of the Family Law Executive Committee, and a partner at Kennedy Partners Lawyers to discuss recent developments in relation to binding financial agreements. Now, John, the federal government has just introduced the Family Law Amendment Financial Agreements and Other Measures Bill 2015 into Parliament.
Correct.
If passed, what are some of the main changes that this will bring?
It will bring quite a few changes, Jessica. One of the changes relates to the clause about specifying amounts for maintenance in financial agreements. Up to now, you've had to specify an amount. You now have the additional option, if this becomes law, of specifying a portion of property instead. The key change, I think, is probably in relation to the statements and the statements of advice that are given, or the process of giving advice and the making of agreements. The clause section 90G and its equivalent in Part 8AB for de facto agreements are going to be entirely rewritten. What will instead be the case is this: you will have to still have the agreement signed by all parties, but it's up till now, the advice required until recently has been you have to advise the clients about what the effect on their rights and the advantages and disadvantages of the agreement. The second requirement will be gone. You just simply advise a client about the effect on their rights. The client will be required to sign an acknowledgement confirming that they've got the advice. Interestingly, that can be done after the agreement is signed. And the statement of advice nor the acknowledgement have to be attached to the agreement. Now, curiously too, the government has brought in the fact that you don't go behind the advice, you don't question whether the advice was in fact provided or not, and the court must find the agreement binding even if some of these requirements aren't dealt with, unless it's satisfied that it would be unjust and inequitable otherwise to do so. Clauses about maintenance will terminate on death. That's a welcome change, which John McClelland, a fellow member of the Maintenance and Property Committee, and I advocated in an article previously. Provisions about maintenance will also cease if parties remarry or enter into a new de facto relationship. The requirements about change in circumstances if one party has caring responsibility for the children will change. Until now, it's material change in circumstances is enough to provide a ground for setting aside an agreement. That will still be the case if you sign them before a separation declaration, or they're made before or without a separation declaration. Post-separation agreements, however, it needs to be an exceptional change, as if there were court orders. And welcome is the fact that the ground for setting aside on the basis that there's been the agreement deals with an unsplittable interest is being repealed.
Okay, so there's been quite a few changes that practitioners might soon have to be dealing with. Now, in the past year, have there been many important cases relating to binding financial agreements that practitioners should know of?
There haven't been huge numbers, but there have been a couple of interesting ones in recent months which are worth considering. One is a decision of Justice Watson, a case of Raleigh, in 30 July 2015, which can be found on Ostley. Now, the parties in that case made an agreement in 2003. They were married, hadn't separated, but it was designed to deal with what would happen if they did, and it was signed 8 days before the wife was due to give birth. Now, the wife claimed she didn't get advice. Now, normally, the husband could point to the statement of advice and the onus would shift to her to prove that issue, but the certificate of advice that then was incorrect and referred to the wife getting advice under Part 90C of the Family Law Act, which doesn't exist. So His Honour wasn't satisfied that shifted the wife's onus. It remained with the husband, and therefore the wife's solicitor was called, found out, it transpired the wife had only had a 15-minute meeting with him, and His Honour considered he hadn't, that is the solicitor hadn't, properly acquainted himself with the wife's rights or advised her about them, so the advice hadn't been given or the requirements hadn't been met. But in the alternative, the agreement was also set aside because the husband had placed a great deal of pressure on the wife to sign it when she was anxious just before birth, and anxious about the welfare of a child. It was very one-sided. There was a disparity in financial resources between them, and he'd also misrepresented a key clause of the agreement. So the lessons from that really are, another thing too important is that the wife's solicitor had been recommended by the husband. So the lessons in my view are, unwise to get involved in the choice of the other party's lawyer, avoid pressuring the other party, avoid signing the agreement close to important life events. More recently and more briefly, there's been a case of Phak and Zhu, P-H-A-K and Zhu, X-U, at the end of October, decision of Justice Benjamin. That was an interesting one. It was set aside on the grounds of mutual mistake. The parties were had bought an interest in what were called the Suburb E apartments, and they both genuinely thought they were worth $1 million. They recited that in the agreement. Turns out they'd been a victim of a scam. The apartments were never built, and they lost the $420,000 for the deposit they'd paid. So His Honour was satisfied that could be set aside on the grounds of mutual mistake. Unusual case, but it perhaps raises the question that if the parties recite in the agreement that they think a property is worth a certain amount of money and it turns out they're grossly out, maybe that could be a mutual mistake argument, and it underlines the prudence of having valuation evidence of some sort at the time, if possible.
Okay, and just finally, what would your best piece of advice be for practitioners to always remember when they're drafting binding financial agreements?
Okay, well, some of this, I probably have a few points which I can go through fairly quickly, one of which I've touched on, two of which actually I've touched on. Don't get involved in the choice of the other party's lawyer. If you can, avoid signing close to major life events like the marriage, the birth, the move overseas, the move of house, when people are very stressed and you're susceptible to pressure. Draft with clarity and avoid ambiguity so that it's not going to be set aside for being meaningless or unenforceable. Deal with trust specifically, if there are any, or likely to be any. Also, have arrangements in the case of what's going to happen if there are children, particularly as we know there's still going to be a material change in circumstances regarding children is enough to set aside an agreement. So if that's likely to happen, deal with the possibilities and consequences of it. And also, very important too, if there's a Part 8AB agreement, they're for de facto couples, emphasise to them and tell them that it will end if they do marry each other. So that'd be a few key points.
That's great. Well, thank you so much for your time today, John.
Pleasure, Jessica.